Okay, good morning, everyone. Again, this is Judge Stanley speaking, and as we noted at the pre-hearing conference, I'm going to ask you all to identify yourselves as well each time you speak. Not only because we need the court reporter, the stenographer, I'm sorry, to be able to record who is speaking, but also, as noted, Judge Lung has a sight impairment, and so he won't be able to see who's speaking. Welcome to the Office of Tax Appeals. Today's oral hearing is going to be for the appeal of Patricia Binns, and it will be held electronically and will be live streamed. The live stream is up and running right now. Ms. Alonso will create a transcript of the hearing, and it will be part of the public record and posted on the Office of Tax Appeals website. To ensure that she can accurately do that, we're going to ask that everyone speaks one at a time and doesn't speak over one another. Speak clearly and loudly, and when needed, Ms. Alonso will stop the hearing and ask for clarification. We're conducting today's hearing electronically with the agreement of the participants. Please keep your microphones muted when you're not speaking so we can avoid feedback and background noise. And if any participant has any technical errors or gets disconnected somehow, we'll take a brief recess to aid that person in reconnecting. The proceedings will be broadcast on YouTube. And just a few housekeeping things before we go on the record. The Office of Tax Appeals is independent of Franchise Tax Board and any other tax agency. We're not a court, but we are an independent appeals agency staffed with our own tax experts. The only evidence that the Office of Tax Appeals has in its record is what has been submitted by the parties in this appeal. My panel members today are Judges Natasha Ralston and Judge Tommy Lung. I'm just the lead for process and procedure today. The panel will meet after the hearing and we will deliberate and issue a joint opinion. We've got a couple of things to clear up prior to going on the hearing too with respect to the pre-hearing conference. I believe I need to apologize to Mr. Catino if he feels like I disrespected him in any way when I joked that I didn't make up the exhibits, especially since apparently I did. But hopefully both parties did get an email within minutes after the conference indicating that. And Mr. Catino is shaking his head yes, that he did receive it. Ms. McDowell, did you also receive that email?
This is Ms. McDowell, and yes, I did receive that email.
Thank you. The other thing is that Franchise Tax Board did request to brief the issue of the estimated tax penalty. And when I indicated that I didn't believe that the panel here needed additional briefing on that penalty, I understand that the Franchise Tax Board thought that I denied it. I wrote in my notes that it was withdrawn, so we had a misunderstanding there. So, Mr. Catino, if you wish to brief that, I'll give you two options. You can either address it in your presentation. So you can either present on that issue during your presentation, or I can give you extra time after the hearing to brief it if you do wish to brief it.
This is Brad Catino for the Franchise Tax Board. Yes, we will address. I will address it in my argument, and if the panel seeks more information, I'm happy to draft an additional brief after the hearing if they have further questions regarding the estimate tax penalty. Thank you.
Okay. This is Judge Stanley. Thank you, Mr. Catino. Then the last thing we have before we go on the record is that Franchise Tax Board did submit a brief on time with respect to the question the Office of Tax Appeals asked that was related to the installment agreements. Then they did not attach their exhibits, and we only got those yesterday. There were exhibits R, S, T, and U, and they all relate to installment agreements and installment agreement fees for tax year 2015. Ms. McDowell, did you receive those exhibits?
This is Ms. McDowell. Yes, ma'am. We did receive those exhibits.
And do you have any objection to them?
No, I do not.
Okay, great. Then I think we're finished with preliminary matters and we're ready to go on the record. Ms. Alonso, are you ready? Okay, Ms. Alonso gave the thumbs up and I see my panel members are ready and the parties. So we'll go on the record in the appeal of Patricia Binns, case number 2107-8200. The date is January 26, 2022. The time now is 9:41. Sorry, just give me a moment. Okay, this was scheduled for a virtual hearing with the agreement of the parties. I am Judge Teresa Stanley, and on the panel with me is Judge Natasha Ralston and Judge Tommy Lung. I will conduct the proceedings, but the panel will equally deliberate and issue a written opinion within 100 days after the hearing. I'm going to ask on the record that you each identify yourselves and who you represent, and we'll start with the appellant. Ms. McDowell, that would be you.
I'm sorry. Yes, my name, this is Ms. McDowell speaking. I'm the power of attorney and I'm representing Ms. Patricia R. Binns in this matter.
Thank you. And Franchise Tax Board?
This is Brad Catino, and I represent the Franchise Tax Board.
We have.
Good morning. This is Ellen Swain. I also represent the Franchise Tax Board.
Okay, thank you. The issues for this appeal are for whether appellant has established reasonable cause or a basis to abate penalties and fees, and that includes for 2013, 2014, 2015, 2017, and 2018. There were various penalties, including late filing penalties, estimated tax penalty, a late payment penalty, demand to file penalty, and some county lien fees and a filing enforcement fee. Ms. McDowell, do you agree that those are the issues today?
This is Ms. McDowell, and yes, ma'am, I agree.
And Mr. Catino?
Yes, this is Brad Catino. I agree.
Okay, this is Judge Stanley. We have not received any exhibits from appellant, so there are none to admit into the record. Appellant did submit some information to the Franchise Tax Board, which is included in their exhibits A through U, which will all be admitted into evidence. Does either party have anything else that they wish to present today? Ms. McDowell, starting with you.
This is Ms. McDowell, and no, ma'am.
And Mr. Catino?
This is Mr. Catino. No further exhibits.
Okay. Neither party is producing witnesses today, so we won't be swearing in anyone for witness testimony. We will just have each side present their position in this appeal. And Ms. McDowell, you may proceed when you're ready.
This is Ms. McDowell. Good morning to everyone again. A lot of this liability that was assessed to Ms. Patricia Benz. Again, we are agreeing that it was warranted, but her problems and the issues arise prior to her first assessment of the 2013 tax year. In the 2011 and the 2012 tax year, Mrs. Benz had dealt with identity theft, at which she was notified of this when she tried to file her own personal tax returns. Her first notice from the state regarding her tax issue came several years after the death of her mother, which I'm sorry, give me 1 second, which is where this liability was created. So in 2013, her mother passed away, leaving both herself and her brother at the time an annuity account that they knew nothing about. In that process, in that years, her brother also passed away, and that then entailed that Ms. Benz was sole heir to this annuity. So during that time, she went to try to get the tax returns filed. When she did reach out to the state and they had stated to her that the returns were filed, she tried to correct that, stating that she never filed any of her own personal returns. It was at that point again, she then decided that she needed to get someone hired in order to try to rectify the situation for her. Unknown to her, the annuity did not pay out any taxes. All she knew at that point was that she received this lump sum amount of money that was in stocks, that was in bonds, and that was in this annuity, and she was to report it on taxes. So she did hire a company in 2015, I believe. After the assessment letter came, she hired a company called BC Tax out of Boulder, Colorado. This company was to file the tax returns, get her tax returns from 2011-12 through the current year, which would have been 2015, to get those tax returns filed and processed for her, as well as deal with any tax debt that would be associated with her tax filings. She was assured by this company that they would assist and help her. That company then got her in touch with Cornerstone Financial Services, which was the company that would be actually dealing with her tax filings. She provided them with all of the information that they requested, and they in turn had indicated to her through emails, through back and forth, that they would be dealing with the tax debt as well as filing the tax returns and getting everything resolved. During that time, a little times after that, her account was levied. She reached out to the company advising that the state had issued levy to her bank account. They attached the funds. She had told them that she was okay with the state keeping the money. She knows that the state owes money. She owes money to the state. She just wants to get a result so she can pay the state off as quickly as possible. They again assured her that they were working on it, that they would be notifying the state of them filing the tax returns, them filing the power of attorney, and they would handle the case for her. 2016 rolls around. She then reaches out to the company again because she didn't get anything in the mail. She didn't get any copies of her tax returns. And at that point, the company didn't return phone calls to her. They were not responding to any emails. No one was returning any calls. An individual from my company at that point, Omni Tax Help, reached out to her and advised to her that we would be able to assist her and we would do a courtesy check to determine what was going on with the state. We obtained the proper documentation in order for us to file the powers of attorney, at which we advised her that tax returns were missing, that the state did assess her and filed substitute for returns for the 2013 and the 2014 tax year. We notified her of the amount that they had indicated that she owed, and we then at that turn immediately got her in contact with an individual, our sister company, that could actually get the tax returns filed. In that process, we also reached out to that company. We did a letter requesting that all of the monies that Ms. Benz did pay them, that they would return them, or she would file a suit against them to receive the funds back because they did not do what they were promised her. In turn, the company did remit all the money that Ms. Benz did pay, and she did. They returned her funds, and she was able to utilize those funds to assist with getting her tax returns filed properly, and also being established on a payment arrangement. So the tax returns did get filed, and I believe that's in the state's exhibits as well. They did get filed in the third quarter of the 2016 tax year, at that point we also helped her in filing all of the tax returns up into the 2017 tax year. After it was all said and done, Ms. Benz did owe a little more than what the state had initially assessed her, at which we established a full payment installment agreement on her behalf. All of the levies and monies that the state did receive were applied to the 13 and 14 tax years. The 2014 tax year yielded a smaller liability than the state had stated, but all in all, she was on a full payment arrangement with the state. In 2018, when the tax return was filed, Ms. Ben's income did go up. She had retired, of course, from public service. She was a teacher in the state of California. She did 30 plus years there. She was receiving pension and then Social Security. And she also had this annuity that she was also receiving money from. And so her income went up. She then owed a new tax debt for the 2018 tax year, at which we notified her of it. She tried to pay it off prior to the tax return being assessed. However, it ended up defaulting her installment agreement, at which we reached right back out to the state. We explained to them the situation. They did reinstate her installment agreement, and she has since paid the full amount of liability on the account. Now, Ms. Benz has never denied on the state after finding out that the taxes were not paid through this inheritance. She did do her due diligence in trying to reach out to a company to rectify the situation prior to her being levied, prior to it creating the liability that it did. Unfortunately, she did run into an individual, a company that did scam her, and she was able to get around that by hiring our company, and we were able again to rectify the problem. She hasn't owed since. She filed her tax returns. She pays what she owes if anything is owed. And the only issue that we see is that it was just a situation where she honestly had no idea how to deal with such a huge inheritance. She trusted the wrong individuals to try to help her fix this problem, thus creating the tax debt, and thus creating the situation that she worked so hard to get herself out of. So we are requesting that you guys do find it, that there is reasonable cause, and that she did do her due diligence in trying to correct the situation once she was advised of it. She did pay off all of the tax debt, penalties and interest. She made sure that her payments after the 2018 tax return liability defaulting, that they were paid on time, and she actually overpaid, and she received a check back from the state because she was diligent in making sure that everything was paid off, because she knows that the liability was hers. So we're just asking for some leniency with removal of the taxes. Removal of the penalties in good faith, and of course, she will continue to remain compliant and do her due diligence in making sure that she's not back into this anytime soon. And that completes my portion.
This is Judge Stanley. Thank you, Ms. McDowell. Judge Ralston, do you have any questions for appellant?
This is Judge Ralston. No questions at this time.
Judge Lung, do you have any questions?
Yes, a quick question for Ms. McDowell. Ms. McDowell, your client pick a Colorado tax preparer to file her returns?
This is Ms. McDowell speaking. Full disclosure, we honestly don't know. She did have them reach out. As we all are aware, when a lien is filed, a lot of companies like myself who deal with tax debt, we reach out to clients and their sales associates, and there are some companies out there that will sell you a dream, and there are some companies out there that will sell you a job and they will complete the job. Unfortunately, it's a situation where she was, of course, I'm not going to say prayed, but she was reached out to, and she felt like she could trust the individual and they would do the job. And at that point, Ms. Benz didn't care if they were in Colorado or California. She was just trying to get the situation corrected. And she trusted the first person that reached out to her, and she paid them to do a service that they didn't do.
Thank you. That's all.
You're welcome, sir.
This is Judge Stanley. Mr. Catino, the Franchise Tax Board can begin their presentation when you're ready.
Thank you. Appellant has failed to establish grounds to abate the penalties and fees imposed for the tax years at issue for two reasons. The first is that appellant's assertion that she was unaware of the annuity income for the 2013 tax year is unsupported by documentation, and most critically, an insufficient justification for abating the delinquent filing penalty imposed for the 2013 tax year. Second, appellant's argument that she was misled by her former tax preparer does not absolve her of her non-delegable duty to timely file her tax return, pay her taxes, or respond to notices for the tax years at issue. To my first point, appellant contends that she was unaware nor received the annuity income for the 2013 tax year. Unlike the taxpayer in the appeal of Morin, appellant hasn't provided letters, emails, phone logs, or any other documentation which would reflect when she learned of the income and what steps were taken to ascertain her tax liability. In the appeal of Morin, the Office of Tax Appeals weighed heavily the efforts taken by the taxpayer to acquire the information necessary to determine his tax liability prior to the filing deadline. The Office of Tax Appeals held that without substantiation of efforts taken, reasonable cause cannot be established. However, even if appellant had the documentation to support her position, the Office of Tax Appeals has held in the appeal of GEF Operating Inc. that lack of knowledge of the law is not an excuse for failing to file a timely return. Moreover, excluding the annuity income, appellant should have known that she had a filing requirement due to W-2 income she received, as reflected on her 2013 California tax return. Thus, appellant has not established reasonable cause to abate the delinquent filing penalty imposed for the 2013 tax year when she filed her return more than 2.5 years after the filing deadline. To my second point, appellant asserts that reasonable cause exists because she was misled by her former tax preparer that her tax returns were timely filed. While respondent does find it commendable that appellant eventually corrected the error, in United States versus Boyle, the U.S. Supreme Court held that reliance on an agent, such as a tax preparer, to file a tax return by the due date is not reasonable cause. Rather, a taxpayer has a non-delegable duty to ensure her tax returns are timely filed. Appellant was on notice that her tax returns had not been timely filed when she received a request for tax return for the 2013 tax year, and then later when she received a demand for tax return for the 2014 and 2017 tax years. Appellant has not explained why she did not respond to these notices or take further steps to ensure her tax returns were timely filed and paid. Accordingly, appellant has failed to establish reasonable cause to abate the demand, delinquent, and late payment penalties imposed. Finally, appellant has not established that either of the two waivers applies for abatement of the estimate tax penalties imposed, nor is there any statutory basis to abate the collection fees that were properly imposed for the tax years at issue. Therefore, respondent's position in this appeal should be sustained. Thank you for your time, and I'm happy to address any questions that your panel may have.
This is Judge Stanley. Thank you, Mr. Catino. Judge Ralston, do you have any questions for the Franchise Tax Board?
This is Judge Ralston. No questions. Thank you.
And Judge Lung, do you have any questions for the Franchise Tax Board?
This is Judge Leon. I have no questions at this time. I will wait till after Ms. McDowell finishes her closing. Thank you.
This is Judge Stanley. Ms. McDowell, would you like to briefly respond to the Franchise Tax Board's position?
This is Ms. McDowell, and yes, I would like to. Just a couple of things. First being, the issue with the tax return filing is because there was an identity theft issue with the 2011 and 2012 tax years, the taxpayer was unable to file those returns because she had to go through the proper channels in order to show that she was the actual individual and it was her who was trying to file her taxes. So that is a process that she had to go through with both the Internal Revenue Service and with the state. She also had to wait and get a PIN in order for her to actually file the returns. Again, that also went into the 2013 tax year as well as, 2013 through the 2017 tax year. And to this date, the client has to file with a specific PIN that she gets every year updated because of the identity theft. So to say that she should have filed on time, there were issues with filing on time because she could not give the proper information in order for her to correct the identity theft issue without filing the previous years. And so you can't file a return and correct the identity theft issue if you don't have the correct information that is reported on the falsified return. So that's one of the issues that we ran into when we were helping her correct this issue. The other thing that I would like to bring to light is, again, we go back to her mother passing, and there was an annuity that they knew that her and her brother knew nothing about. So when that whole situation happened and the will was read, she, being someone who was W-2, who was trying to file the returns prior to the 2013 tax year, again, she never denied not trying to file the return. In that, we also mentioned that she never denied not owing. She's always stated that she knows that there's a tax debt because her income went up. She had issues, again, by trusting the wrong individuals. We're not blaming this company for her owing. We're blaming the company for taking money and not fixing the issue. So I do want to clarify that portion as well. We 100% stand by it is the taxpayer's responsibility. We also stand by the fact that it is the client, it is the taxpayer's responsibility to make sure that she is aware and she's paying notice to anything that comes in the mail. The third point I would like to state is we did file a power of attorney with the state of California in 2016 when we took over the case. We did speak with representatives consistently explaining the situation at which we were advised on how to handle, and we were given dates and times to make sure that we're filing these tax returns, which we met every deadline that the state gave us. We also, again, verified that things were received when documentation were requested, and we set up a payment arrangement that did full pay the liability that she owed. I do want to reiterate that the client never once stated she didn't owe, never once stated that that this tax debt wasn't hers, and she took full responsibility and she did pay. Not many clients can, not many taxpayers can state that. In this case, we have also shown good faith to the state. She hasn't owed since the 2018 tax debt. She files her tax returns and she pays on time. So is this one-off where we have an individual who was taken advantage of, who was promised the world to try to fix a problem that she knew existed, and in that situation, she just trusted the wrong person? Yes. Is that the state's fault? No. Is that her fault? Yes, we will take responsibility of it. But we did everything in our power, and she did everything in her power to correct it, and she did correct it. We're just, again, asking for a little grace in this, in requesting the penalties be removed because we feel that we did show reasonable cause as to why she shouldn't be penalized for things that were out of her control.
This is Judge Stanley. Ms. McDowell, is that the end of your statement?
Yes, ma'am.
Okay, thank you. This concludes the hearing. The judges will meet and decide the appeal based on the documents and testimony. Well, we don't, oh, excuse me. I failed to ask my fellow judges if they have any further questions, and Judge Lung has raised his hand, so I assume he does. You can proceed.
Thank you, Judge Stanley. This question is for both parties. Start with you, Ms. McDowell. I'd like to get a little more background as to what happened at the IRS for these particular years. For example, were her tax returns filed on time with them? Were they delayed? If they were delayed, did the IRS pose these type of penalties on this?
This is Ms. McDowell speaking. Just so I have clear understanding of your question, you're asking for background as far as after the 2018 tax year, has she been current and compliant with the IRS in the state?
No, I'm asking about these years, 2013, 2014, 2015, 2016, 2017.
Okay. You're asking why she wasn't compliant? I'm not understanding the question. I'm sorry. And this is Ms. McDowell speaking.
Yes, I'm asking whether she filed on time with the IRS, and if not, whether the IRS also imposed late filing, late payment penalties on her.
This is Ms. McDowell speaking. Yes, all of the tax returns, like the state, were also filed lately. Filed late. She also full paid the tax debt with the Internal Revenue Service, and they did release $98,000 worth of penalties, at which they did refund her for those due to her showing that she did have reasonable cause to request the penalties to be removed due to the circumstances that we presented to you today. So the Internal Revenue Service did agree with our findings regarding it not being the taxpayer's fault, and she did have good filing. She did file her tax returns prior to the 2013 and the 2012 incidents where she filed on time and paid on time. They never had an issue up until the 2013 tax year, and they did agree with removing her penalties that were assessed for the taxes that were owed.
This is Judge Long again. Ms. McDowell, did the IRS remove the penalties because of a good filing history or because of the identity theft?
This is Ms. McDowell, both. So she showed reasonable cause, and part of that reasonable cause was that she, prior to the issue, she had good faith in filing her tax returns. And after the issue, after her paying, she also showed good faith in filing the tax returns and paying on time. So they did relieve her of the penalties for both of those reasons.
And did you provide the Franchise Tax Board with the documentation to indicate what the IRS did?
This is Ms. McDowell, and no, I did not provide them with that information. That is documentation that we can submit if requested. Normally with the state of California, in my experience with them, I tend to get back from a lot of reps that we're not like the Internal Revenue Service. We have nothing to do with the Internal Revenue Service. Our rules are our rules, and we don't necessarily cross-pollinate unless it's a payment arrangement and they need proof of that documentation. So for that, I do take responsibility if that wasn't submitted, but that is documentation that we can show.
Thank you, Ms. McDowell. Mr. Catino, setting aside the good filing history, which I know the state of California does not have in its toolbox for relieving penalties, or if the IRS had relieved some of those penalties because of identity theft, would that be sufficient reasonable cause for you folks?
Judge Young, to answer your question briefly, and then I'll give a more expansive answer. Yes, if any of the penalties were abated for reasonable cause, FTB would be interested in having that information, and then may revise its position as appropriately. The Franchise Tax Board has requested information from the IRS for the tax years at issue. As Ms. McDowell stated, they mirror what happened at the state level. The tax returns were similarly filed late for the 2013, 2014, and the similar penalties were imposed. It appears from FTB's records that all the other penalties for the other tax years have not been abated. However, the 2013 tax year, it appears that the delinquent filing penalty was abated. However, as you stated, it appears to be part of the IRS's first-time abatement program and not due to reasonable cause. However, if appellant has information that the 2013 tax year delinquent filing penalty was abated for reasonable cause, we would take a look at that. But based off FTB's records, currently it looks to be part of the IRS's first-time abatement program for the 2013 tax year, as opposed to abatement for reasonable cause.
Thank you. That's all my questions, Judge Stanley. Throw it back to you.
This is Judge Stanley. Thank you, Judge Long. Judge Ralston, do you have any additional questions?
This is Judge Ralston. No questions. Thank you.
This is Judge Stanley. I had been going to ask about the identity theft and how it specifically did affect 2013. It sounds like it's possible that the IRS did abate those, the 2013 at least penalties. But I think it would be helpful to the Office of Tax Appeals because our record does not include any information with respect to why some of the penalties were abated and for which tax years. So, Ms. McDowell, do you think if I keep the record open in this case that you would be able to submit that to the Franchise Tax Board and to the Office of Tax Appeals?
This is Ms. McDowell speaking, and yes, we can submit all of our records regarding that in the paperwork for all of the years that were removed through abatement.
Okay, this is Judge Stanley. How long do you think you would need to do that?
Just a week. I'm sorry, this is Ms. McDowell speaking. Just a week because a lot of that information is archived with our company, and we would have to pull it up in order to get it sent to you. So I would say no more than a week time to turn around.
This is Judge Stanley. Thank you, Ms. McDowell. To be safe, why don't I hold the record open and give you 2 weeks to get that to us with a copy to the Franchise Tax Board. And then Mr. Catino, how long would the Franchise Tax Board need to review the additional information?
Similarly, if we could get 2 weeks to respond to the information, and then also, this is Brad Catino. Actually, can we request 30 days time frame to respond? And then also, we would like to submit what FTB's records reflect in regards to information that we've received from the IRS regarding the 2013 tax year.
Would you like, this is Judge Stanley, Mr. Catino, would you like to submit that first or just after you receive whatever appellant has?
I think to make it easy for the Office of Tax Appeals, this is Brad Catino, we would like to respond after we receive information from appellant. We could have 30 days to respond and then provide information regarding what, to clarify if we need additional information from the IRS to explain what happened for the 2013 tax year. I think that would be helpful as well. So I think after appellant has responded would be appropriate. Thank you.
Thank you. This is Judge Stanley. To be fair, Ms. McDowell, would you also like 30 days? Because I'm going to give the Franchise Tax Board 30 days to respond to what you produce.
This is Ms. McDowell. That's fine. And I would like to just verify where we're sending that information to so that we can make sure it's there timely.
Yes, I will issue another order holding the record open and putting the dates and where to send the information. So I'll do that after the hearing, so that will be clear. And what I'll do with the Franchise Tax Board's response is set their response to be due 30 days from the date that they receive your documentation. And that way we don't necessarily have to hold the whole thing up for 60 days if you get it sooner. Does that sound okay, Ms. McDowell?
This is Ms. McDowell, and yes, ma'am, that's fine.
And does that sound okay to you too, Mr. Catino?
Yes, this is Mr. Catino. That sounds great.
Okay, then now I'll go back to my earlier statement that this concludes the hearing, and we will not be issuing an opinion until sometime in the 100 days after we close the record. So that'll be the official date that the clock starts ticking. So we'll recess the hearing, and it will reconvene at 1 p.m. for another hearing. Thank you all for participating today, and have a good day.
Thank you.
Thank you.
Thank you, judges.